Dear students, so welcome to this particular revision course. As I said in the class, I'll be giving some video lectures where we'll be revising HOE 7120. So that would be rights, obligations, and liability of actors on the internet. So, well, these are three or four video lectures that I'm recording where I will talk about whatever has been covered in the class. And well, this could either serve as a revision for those of you who already attended the lectures, or well, those of you who could not attend the lectures for whatever reason, now you have everything in Moodle, including the notes and also video lectures. So, it's an interesting topic, and we have covered a lot, I believe, for 3 credits worth of the course. And well, in this particular course, we have looked at all the possible actors in the internet sphere, yeah, and when we look at these actors, we have to understand that they have, certain rules to follow, and these are very interesting rules. Um, a lot of it has happened quite fast. Now, as you can imagine, the internet is quite different from what it used to be 20 years ago. And the origins of how internet and social media and all these platforms like YouTube and search engines like Google work, it is very interesting because they have evolved since what, the 1990s. And there's also now more of e-commerce happening, and of course now things are really moving very far ahead. I remember even about 15 years ago, um, there would be bachelor defenses, and the thesis would have titles like, is internet sorry, a basic human right? And of course now you can see, well, of course, if you look back, it sounds a little funny, especially because how things have changed so much, and now internet is a very essential part of life. And so in this particular course, I've divided it into four areas, and one would be the old school traditional rights, obligations, and liabilities in the non-digital world, yeah, as we have always known them. So there are three differentiations out over here, and we're looking at case laws from the 1860s, and they deal with this topic admirably. I mean, they've done a very good job so far. But that was old school. And then we look at how the laws have evolved in the European Union, and there has been a lot that has been going on since the year 2000. So we look at that. Now that's almost 21 years. So you can see how the law has evolved over a period of time. Then there is the US legal aspect. So I'll spend some time on the US law situation, and very interesting how it has helped the US to evolve into this very dominant position with regards to internet, and all the top internet companies are based in the US. And of course, well, there's a strong legal basis for all of these things. So we look at that as well. And then there are some miscellaneous topics about human rights and the right to be forgotten. And then that should cover more or less all these things. If you look, there are also case laws, well, quite a lot of case laws actually. And at the end, I hope you get a very fair idea of what this topic is about, and hopefully it can help you to get a better understanding of how things stand. Now, remember, we are just looking at things from a very restricted aspect from a European Union and the US viewpoint or viewpoints. We are not going into more details, but this is a bachelor level course, 3 credits. So I think you have enough on your hands anyways to keep you busy. All right. So for today we look at old school issues, and number one would be, well, there's something known as defamation and slander, and this is something that's been around for hundreds of years, and in different countries you have different rules. In many English speaking countries, defamation is a civil offense and also a criminal offense, but in other countries, I understand that defamation is purely a criminal offense, and so of course there are strict guidelines to be followed in this regard. Now, besides defamation and slander, I mean, we are looking at old school. That would be, you write a letter to the newspaper editor, or you get something published in the news, or it's 30 years ago, 50 years ago, and something is published in the magazines, or it's telecast on TV. And then, of course, in those times things were very different. And in that era, of course, number one, things moved very slowly, and the law also was quite well established. Then we look at the issue of freedom of expression versus right to reputation. Again, in the non-digital era, this is a very well established area of law, and it deals with different concepts. And what's interesting is when you try to copy and paste something from the non-digital era, the laws from previous occasions and years, and then you try to impose them into the digital context, you can see how they don't always fit in very well. So 30 years ago, if there was something defamatory published in a newspaper, who would be responsible? Yeah, and how would the law deal with this situation? And of course, if you now compare it with nowadays, there's an online portal and people post all sorts of rubbish. The comments are horrible. Then you can always see that the same old rules cannot apply in the new context. And then we look at liability. Liability is a very loaded concept, and we're looking at it from English law perspective. So then there is liability, and then there is something called vicarious liability, in which case I will sort of bring out three different case laws, and they sort of explain how the evolution takes place. Now remember, this is very important. Today we are dealing with all of these things in the pre-digital or non-digital era. All right, and so this gives you a historical background into understanding how you have rights, obligations, liabilities, and duties, and how these play a very important role, and how they have served as a platform to go to the next level, which is the same rights, obligations, liabilities, and duties in the internet era. All right. So first of all, we look at defamation, old school defamation, and if you see the notes, well, it's quite straightforward and simple what they deal with. Reputation, everybody has a reputation, and if you injure the reputation of another person, then it is a problem. All right, and well, it could be libel if it is published, or if it is oral, then it is slander. I mean, this is a very loose understanding of it. There are, of course, more detailed nuances which you can see in the context of the notes. And so who can be defamed? It could be an individual, a private person, it could be a company, and so all of these are aspects. Now the law basically, and we're looking at some UK based laws in this regard. Now I know, well, after Brexit, UK is not exactly our best friend when it comes to understanding these aspects. But remember, this entire course is a very comparative course. You're looking at the European Union, and you're looking at the US, and you're looking at how both of them work. So we are trying to understand how the non-English speaking world tries to make sense of the English speaking world. Yeah, so don't worry, it'll be okay. All right. So the UK law basically says that a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant, and of course, well, serious harm could also include serious financial losses. Yeah, and so of course, these are the bare bones issues that arise. And of course, when you look at law, there are also defenses. So if the statements are true, then it's not a defamatory statement. Or if there are privileges that are being exercised, and there are two types of privileges: absolute and qualified. So again, in the notes we'll see them. Then these are also excused. And if it's a fair comment on a matter of public interest, well, that's not defamatory. Or if the words were published innocently, whoever the publisher was took reasonable care and had no reason to believe that these were going to cause problems, or offers to make amends, then it's okay as well. Yeah. And lastly, of course, if the publication is in a matter of public interest, and then you would see that in the context of politicians, for example, the prime minister of the country, and she or he is doing something horrible, and now you have to report it. Would that make it defamatory? Well, not really, yeah, because it's in the public interest. And then when you talk about privileges, there are absolute privileges like legal proceedings. So, it's something happening in a court of law, you're recording it, reporting it legally, properly, and then in that case, you have an absolute privilege. And a qualified privilege would be if you have a duty, for example, it's a company, and then, you are the auditor or the accountant of the company. And now you have to say that, well, all this money went down the drain, it was wasted, and it was a stupid idea. You don't say it that way, but of course, yeah, that's your job, you have to do it. And so you have to bring out all these statements, some of which may be uncomfortable for some people, but that's your job, it's a statutory duty. And so that would be, again, a qualified privilege. All right, so we looked at these aspects, and in the United Kingdom there have been some amendments to the defamation law, and so again, more freedom for the press, if you may say so. But at the same time, there is also this sort of weighing up of aspects, and there are some responsibilities as well, or more, you could say, in the context of restrictions regarding what you can do with your right to express yourself. And so there have been some complaints from the journalists, for example, or the newspapers, that the burden of proof is this issue, and then it's sort of tilting in the favor of the plaintiff, and it's hurting the defendant. So a lot of interesting things here to see, and of course, well, it's a tight balance, because you want to protect the reputation of people. At the same time, you want to protect freedom of expression. And so in the non-digital or pre-digital era, these were the simple problems that people faced in life. All right. And so basically, this is something that we are talking about more in the context of how your parents' generation or the generations before them would have approached this topic. All right. So then we are looking next at freedom of expression versus right to reputation. And this is, of course, as you can imagine, a very loaded situation here. Now remember, this is what causes all the problems, right? So if you remember all the fun years when Trump was the president of the United States, and the things he used to say and do on Twitter, and just used to turn the whole world upside down with his tweets. And of course, there were a lot of questions at that time about freedom of expression. And that also led to a lot of, well, I don't know if it's directly connected or indirectly connected, but a lot of online hatred was spread. And, well, depends on who you ask. Some people would say, it's online, it's truth. Truth is bitter, and that's why people feel it's wrong. Because snowflakes can't take the truth, as they would say. Yeah. And then there was also this entire cancel culture, the woke culture, and all of these very interesting topics. Now again, we don't take a stand over here in that context. As lawyers, we are looking at issues from a legal viewpoint, and so of course, very interesting developments on all sides. And really, you can see here the transition phase. So we're looking at the pre-digital world and what the views were at that point of time, and then how the internet started, and so the internet brought in very good things, and of course some negative things as well. And so social media, again, it's a wonderful tool. It helps you to connect with your family, with your friends. You could live 1,000, 10,000 kilometers away from your family or friends and still feel as if you're next to them because of social media. But this ease of communication and the inexpensive way of communicating also can result in a lot of legal issues arising, because people are becoming more outspoken. People talk more, express themselves much more online than they should for their own benefit. And so of course, yeah, this results in situations which lead us to a problem, right? Because the old laws cannot really apply in this context. And so we have this freedom of expression and the digital turn that it has taken. And of course, on the online, in the online environment, you have these gatekeepers, Facebook, Twitter, Google, YouTube, and of course, they have certain rules that they implement, and so what are their responsibilities or liabilities? Now, this is not a simple question anymore, because as you can imagine, Google is the number one search engine. Facebook has 1 billion users. Twitter has like 600, 700 million users. These are big numbers. Yeah, and then as you can see again, Trump, the minute he was not the president anymore, Twitter disconnected his account, Facebook banned him, and then so you can see how you're left out. Now it's strange, because Twitter uh, you know has allowed the Taliban from Afghanistan to have a Twitter handle, but not Donald Trump. So the question arises, is Donald Trump really that bad, or is it just that different rules and not enough clarity, and also this high dominance of different companies, which is quite unprecedented. Yeah, I mean, in the sense that, for example, if you write something nasty and Delphi bans you or Helsinki Sanomat bans you, how does that matter, right? Yeah, but now if Facebook bans you or Twitter bans you or disconnects your account, then of course it's a different ball game altogether. So when we look at all of these situations, there are these European Court of Human Rights principles that have sort of been deduced from the different case laws, and so these are interesting to see, and we try to look at some of these in the article. So there is the principle of the freedom of expression. Yeah, so everybody has a right to the freedom of expression, and then of course everybody has a right to participate freely and without fear in discussions and debates on matters of public interest. Now you see already what's happening here. You're taking the old school way of thinking about freedom of expression and trying to interpose that in the digital era, and so, well, what is public interest? These are important aspects that come up. Then, what are the rights of journalists and the media? How important are they? And then, of course, well, this also brings us to the situation of fake news, for example. Yeah, and everybody gets sort of blamed so easily. CNN is seen as liberal, and Fox Entertainment in the US may be seen as right wing. So, who do you believe now? Then there is also this issue with self-censorship that's happening a lot. I remember myself, I used to say a lot of things in the classroom, but I can't say them during the video lecture, because this is going on YouTube and this could be misinterpreted. And then, of course, what this results in is that you have to think 4 times, 5 times before you say something, because as a lawyer, whatever you put online, you should ask yourself, how will it appear if I have to explain my Facebook or Twitter post to a judge? Yeah, when you think of it that way, then it sort of chills your online activities. Because if you put up stuff online, the last thing you want is your mom or dad calling you and asking you like, "What the hell are you writing?" Yeah, it becomes a bit awkward. And then there is the principle of proportionality. Again, very, very difficult to balance out. Then, how do you deal with hate speech or incitement to violence? Now, in the European context, there have been some developments in this regard, and now most countries have outlawed hate speech, except for, I believe, Estonia and one or two other countries. I think there's Poland and then somebody else. The question here is, I say something that's nasty. Is that so hurtful that it should be banned, or is it just freedom of expression? And as long as it doesn't hurt you or bring you any fear of being hurt or injured, then it's okay. So again, very very difficult questions to deal with. And so I believe in Finland there have been a lot of these situations that have been arising, and so it's very interesting sitting in Estonia to see how the Finnish authorities deal with hate crime, and especially during elections, and you have the right wing parties, and then they say horrible nasty things against certain religions or immigrant groups and things like that. So again, very interesting to see how to juxtapose what you would consider as a normal human right vis-a-vis freedom of expression. And then there are these defamation laws, and again they have to be proportional, because you have to consider the concept of how much is the injury to reputation, and what is the other side, which is freedom of expression. And everybody agrees that politicians will have a lower standard as far as criticism is concerned. So they should be more criticized, because that's their job, to be in the limelight. And the same also goes for public figures. But again, you can see how this is playing out in different forms. And then facts and opinions or value judgments. Yeah, everybody has their own value judgments, and they're not the same as facts. So again, interesting to sort of draw a line between these situations. 2 plus 2 is equal to 4. That's not a value judgment or something. It's a fact. Sun rises from the east, sets in the west. We understand this. These are facts, and they are straightforward. But value judgments tend to be a bit more complicated. When you're trying to criticize somebody and you're trying to say that this person is wrong. So again, a lot of problems can arise, not only in the print media but also online. Then you have defenses. These are laid down in detail. And then of course you have to be careful about how exaggerations or provocations or ironies or satire, these things play a role. And again, these are very interesting aspects. Yeah, so this is well covered over here. Vulgarity, offensiveness, are these the new norm? How do you try to protect children online? This is not a problem in the context of newspapers or print media, but online is a different ball game altogether. And so we come to what is known in social studies as the post-truth era. All these fancy things. And so we have seen that, for example, with the coronavirus situation, the pandemic, the vaccines, and then all this resistance that certain groups have. Now, Finland, I believe, has reached 80% vaccination rate. Compare that with Estonia, for example, which is 56% as of right now. And you can see how civil society has brought up the good, the bad, and the ugly side of debates, and this entire discussion about safety of vaccines. And all the people who are making these comments are and they are deriding and devaluing the opinions of experts and questioning their expertise. So you can see how all of these things play a role over here. And in the European Union context, well, a lot changed when we looked at the e-commerce directive starting from 2000. So we can safely say that today's lecture is more about the pre-2000 era, all right? And so trying to understand these concepts has its own, issues over here. Then there is this aspect of ISP liability. So there's this article from 2012, and already looks at various things. So So here you have a situation where you have two different types of legal systems in play. One is the US, and they evolved this entire idea of having safe harbors and ISP, internet service providers, being free of liability in certain situations. And this liberal regime has led to a situation where American companies now dominate the internet. But you compare that with the European Union and the rest of the world, you see how initially they tried to follow the US approach, and then they realized that, this is not working out. It's only making Mark Zuckerberg and the Apple guys and eBay guys and the Amazon guys richer and richer, but it's not really helping society. And so of course you have now this sort of variation over here. So internet service providers liability and safe harbor provisions are the initial starting blocks of this exercise, where you can see 20 years ago how this sort of entire internet regime was developed. And well, here we are today. Okay, so now maybe one last thing we look at, and that would be liability, and how is liability understood. So again, you have some articles here dealing with liability in the context of tort law. Now, what is the tort would be an English speciality based on case laws, of course, but it's a civil wrong, and it is not, how would you say, actionable by the normal forms, and the appropriate, it's not from arising from a contract or something, and the appropriate remedy would be, suit for damages. All right. So what does this imply? Well, let's say you and I enter into a contract and I mess up, and now you are not happy about it. So we have a contract, and on the basis of the contract, you can sue me. Now this would be a civil wrong. Now, what if we don't have a contract, and I do something and that affects you? Now, there are some case laws on this, very interesting case laws, three of them. There is Rylands versus Fletcher, old school, really old school. And then there is the polymus cases, there are these ship cases. And then there is this Donahue versus Stevenson, which is like the final case in this regard. And this, you can see, shows how English law developed with regard to liability. Now, liability could be two types. I bite you, so of course I'm causing injury to you, and let's presume this is a civil wrong. Well, in that case, you can sue me. Now, what if my dog bites you? Yeah, well, you can't sue my dog, but I have my dog's leash in my hand. I'm taking my dog for a walk, and my dog has now bitten you. And in this case, well, I am liable. I'm the owner of the dog. You can't send the dog to prison. You can't tell the dog to pay a fine in dog money or something. That doesn't exist. The same also goes, for example, let's say you go to a restaurant and you're eating the food and it's not properly cooked and you become sick. So who do you sue? You don't sue the waiter or the cook. You sue the owner of the restaurant, right? Because that's what you are going to do, because you're not concerned with these people who are in the middle. There's this vicarious liability. The cook is not working in her or his independent position. He or she is an employee, and so you have to sue the employer, the restaurant owner, the manager, all of these people. So this is an interesting aspect, and one of the first cases was Ryland versus Fletcher from 1868. Very interesting, where the owner of land, without willfulness or negligence, uses his land in the ordinary manner of its use. Though mischief should thereby be occasioned to his neighbor, he will not be liable in damages. I'm doing everything without negligence, without any bad intentions. I have my land, I'm working on it. Something goes wrong, well, happens. But if he brings upon his land anything which would not naturally come upon it, and which is in itself dangerous, and may become mischievous if not kept under proper control, though in so doing he may act without personal willfulness or negligence. He will be liable in damages for any mischief thereby occasioned. So, I'm from India, I'm living here in Estonia. Let's say I miss India and I decide to bring a tiger from India and keep it as a pet in my house. Yeah, well, I'm sure I have very good intentions, but if that tiger escapes from my house and goes and attacks somebody, then of course, I am liable over here. Now, maybe you would say, well, this is a criminal act, right? So, the police will deal with this. But in English speaking countries, it could be a criminal act, in which case the police will take action, and a fine may be imposed or imprisonment or whatever. But at the same time, you can also carry out civil proceedings and file a suit for damages. That's what you see in the US. You file a suit and you want €1 million in damages. Why? Because tort law. And so this is an interesting case about underground mines, and somebody had dug a mine, and the person next door, the neighbor, had a lake, and so this guy who was mining didn't quite realize how close his mine shaft was to the lake, and now the lake sort of uh, there was a hole, and the mine shaft got flooded. And so again, very interesting to read, 13 pages, old school, as old as it can get, from 1868, and it talks about liability as English law understands it. Then there was this polymus case. There were two of these. Basically, this was during World War I, 1914 to 1918, and just a bit after that. So a lot of shipment was taking place. A lot of ships were moving around, and they were carrying ammunition and dangerous cargo. And so now you have a situation where it's at the harbor, there is a dock, and there are 2-3 ships next to each other. And the workers who are loading one of the ships, they commit an error, and because of this, there's a big fire and an explosion, and the ship gets badly damaged. So what is the liability? Well, who was the manager of these workers, or if they are outsourced, then which company outsourced this job, and who was liable for the damage to the ship? Now, at the same time, one ship got damaged, and now there's a second ship, completely innocent, no involvement at all, but explosives, there are explosions and stuff on the first ship, and as a result of that, the second ship gets damaged. So now the question here is, who's responsible? You see, there's this chain reaction, and very interesting case. These two, they're from the 1930s, so it was arbitration, and then it went higher up, and you can see how the issue of liability has evolved, and vicarious liability as well. And then again, what happens in English law is you sort of end up having conflicting laws, and now you're not sure which law to follow because of case law tradition under common law. And so then there was this final case, which was Donahue versus Stevenson from the 1930s. And the manufacturer of an article of food, medicine, or the like, sold by him to a distributor in circumstances which prevent the distributor or any consumer or anybody from discovering by inspection any defect, is under legal duty to the ultimate purchaser or consumer to take reasonable care that the article is free from defect likely to cause injury to health. A bit of a mouthful, yeah, that's English. So basically what's happening here is a manufacturer made this bottled, some liquid, and it was some ginger beer. Yeah? So, but it's bottled, and it's a dark colored bottle, so you can't really see what's inside. So it's not see-through, and it's not transparent. And so the manufacturer made this batch of bottles and sold them. And so here is now a restaurant guy. He bought a big bunch of these bottles, And now a customer comes, in this case two ladies came, and they ordered that drink. And well, so the restaurant guy gave her the drink, she opened it, drank it, and then turns out that there was some worm inside or something. And the restaurant guy had no idea because the glass bottle is opaque. The person drinking it had no idea because everything's opaque, so she was just drinking straight from the bottle. And when the snail finally came tumbling out, some decomposing snail, it was a shock to everybody. And the person who drank it, well, she had shock and severe gastroenteritis. Well, that's also a reason why I stick to vodka. Can't go wrong with vodka. All this other stuff, well, anyways, in this case, ginger beer, yeah, obviously the alcohol content wasn't enough to negate whatever was inside. Well, yeah, 40% alcohol does its job. Not in this case, obviously. But anyways, the question that came up here is, who should this victim sue? Should she sue the restaurant owner, because he served her the bottle of ginger beer? But the restaurant owner is like, I don't know, the manufacturer sent it in this way and I didn't open it before that. So whose liability would it be? So as you can see over here, in the pre-digital era, yeah, these were the simple problems that people had in life. Who's liable? You decide that, and that's the end of the story. All right, and so we have seen here that these concepts of defamation, freedom of expression, and liability, especially vicarious liability, have developed over centuries and are well settled in law. And that's where we end today. So you read all of this stuff. There are all these articles over here, and some case laws. And this would be the first topic: traditional rights, obligations, and liabilities. And remember, traditional. Yeah. And these cover all the issues very well. So once you digest all of this, then we go next and we look at the obligations in the European Union, starting with the e-commerce directive from the year 2000. And now finally we have the copyright and the digital single market directive of 2019. There is also this new Digital Services Act that is being spoken about. In the future it will come in. But let's stop here for today, and I hope this traditional sort of this revision of traditional responsibilities and liabilities was helpful. So see you again next time. Goodbye.